This hearing is the matter of case number CFI 047-2022 and is being held by way of video conference before Justice Wayne Morton. The claimant is represented by HFW. Lead counsel is Mr. Paul Toms. The defendant is represented by Clyde & Co. Lead counsel is Mr. Richard Liddell.
Good, thank you. Well, gentlemen, thank you for coming on. I got a message earlier today that you wanted to adjourn this pre-trial review, which I was frankly nervous about, because this trial is due to start in 4 weeks. And so I'd like to know what's going on and what you anticipate happening between now and the trial, and indeed whether the trial can still go on. So I don't know who is the best person to start me off on answering those questions.
Your Honour, if I might, I'm Mr. Toms for the claimant.
Yes, thank you.
As you know, I think from the correspondence that's been before you, my learned friend, Mr. Liddell KC, has an anticipated application to re-amend his defence. So I suspect in the circumstances it may be more appropriate for him to address you first.
Yes, thank you. Mr. Liddell?
Yes, Your Honour. There have been some documents recently disclosed by the liquidator. The documents were provided to the parties on the 11th of September 2023. Your Honour might recall making a non-party disclosure order in relation to the liquidator. That order was then enforced in the local courts, and the documents, as I say, were provided very recently. Those documents have been reviewed by my instructing solicitors, and we are in the process of considering what amendments need to be made to the defence. As things stand, it was agreed with claimant solicitors that we would provide draft amendments by 12 p.m. this Wednesday. There were some toings and froings parties as to dates, but that was the date that was settled upon. And the intention is that when the claimant are in receipt of those amendments, they will then it will be necessary for them to review them, of course, and to inform us whether or not they oppose any of the amendments, and if they do, then how we deal with those. So as things stand, the amendments haven't been provided to the claimants, and it's for that reason really that we propose this PTR being adjourned, so that the parties can see actually if there's going to be any objection, and whether or not these amendments can be dealt with in sufficient time before the trial.
All right. Well, all right. Well, now I understand it. What I would like to do, of course, is get to the point where we can make a decision about whether the trial is going on sooner rather than later, and I'm sure that's in everybody's interests. So your proposal then is that you will provide a minute of the proposed amendments by midday on Wednesday, and of course, Mr. Toms, you don't know how long you'll need to consider them. It'll all depend what's in the minute.
Absolutely.
But I'm just wondering if it would be a good idea to, I suppose the problem is we just don't know where this is going to go. If the amendments are innocuous, Mr. Toms, you might go back and say the amendments are consented to and the trial can proceed. But on the other hand, if they're going to be disputed, then it's a whole different scenario. Well, all I can say, I think, really, is that I will obviously do my best to accommodate any requirement for urgent hearing. I have other commitments, of course, over the next little while, but hopefully we can use my time zone differences to advantage. And I don't know how you gentlemen are placed over the next little while either, we'll see. But in terms of timing then, Mr. Toms, you would presumably be able to form a view. If you get it by midday on Wednesday, you should be able to form a view by the end of this week as to which way you're going to go, I would think, wouldn't you? Subject to instructions, of course. Subject
to instructions, subject to the scope of the amendments, but yes, in principle, we would anticipate being able to say yes or no, whether we have the time to formulate a detailed response of the kind that one might need for a contested application, but certainly to give an indication of where we are.
Yes, all right. Well, I'm not available on Monday at all. I'm in the air and got commitments and so forth. But the rest of that week, I should be able to. The rest of next week, I should be able to accommodate something, depending on how long you want and when it is. because obviously we need to get on this as quickly as possible. Just on an optimistic note, assuming that we are proceeding in 4 weeks' time, I didn't have any issues in relation to, there are just a couple of minor matters that I wanted to raise in relation to the hearing schedule and things of that sort. You're proposing, I think, to sit from 9 till 4. I don't know if you gentlemen are going to be in Dubai. I'm not sure whether I will be or not. I probably won't be. I'll probably be doing it by video, but that's not going to be a problem, is it?
Your Honour, I plan to be in Dubai. I'd understood that this was going to be an in-person hearing because there was a recent direction giving permission for the experts to attend by video. But obviously, yes. Your Honour, we're in your hands. I think that.
Well, do you see a problem with me participating by video?
I'll just need to take instructions, Your Honour, on that.
Right.
Can you just give me 1 moment?
Yes, certainly.
So I'm trying to do that as well at the same time, but by email. I'm not with my solicitors.
Thank you. Well, if it is a problem, there's no need to deal with this now because we don't know whether the trial's going ahead as of now. So if you could just get instructions on that and let me know. If you do want me to be there, I can be there. Assuming, of course, we've got a trial.
Your Honour, I think if you are going to be sitting remotely and the expert's going to be attending remotely, then obviously then we can all attend remotely. I think some kind of hybrid version is not going to work and probably not being suggested. So, but perhaps we can liaise with the claimant solicitors over the course of the...
I'll leave you to confer on that. I'm happy to go with whatever you want. I'm happy to come to Dubai if you want me to. I'm happy to do it remotely if you want. So I'll leave that in your hands, and perhaps next time we get together we can talk about that. The one thing I do want would mention is just in relation to the experts. I can see some real advantages. I know they're giving their evidence remotely, and that makes it a bit harder. But I can see some advantages in giving them their evidence concurrently because they do respond to each other's views. And I think it would be helpful to me if they get the opportunity to comment on each other's views. And there are, of course, as I'm sure you're aware, gentlemen, there's a spectrum of activities that you can do a spectrum of ways in which you can do concurrent evidence. What I had in mind perhaps for this case is what I sometimes call hot tub light, which is a rather pejorative expression, but the way that works is that you give each expert an opportunity to make an opening presentation if they wish, for say up to 30 minutes. They're sworn in together. They each give an opening presentation accompanied by demonstrative exhibits if they want. And then cross-examination follows in the ordinary way. So the claimant's expert would be cross-examined by you, Mr. Liddell. But during that cross-examination, I can ask questions of the witness being cross-examined, but I can also ask the other expert to comment on the answer that's just been given. And then that process is followed with the other expert. And then after that, there's an opportunity for the experts to question each other. And then I get another go to question them both jointly. And then you gentlemen would re-examine. So it has some similarities to the conventional system, but it also has the advantage of some degree of concurrency. It does mean that you don't need an agenda, you don't need a list of issues to go through, and it's a bit easier than if you're what I might call full strength hot tubbing. But anyway, think about that, gentlemen. Again, that's something else you can take instructions on, but I'd be keen to do that. And on the previous hearing schedule, if we're going to do that, I think there was anticipated perhaps to be a bit of a gap somewhere. If we're going to do the experts jointly, I think we could do them perhaps on the Thursday, so that if there was a gap, if that meant that instead of starting the experts on the Wednesday afternoon, if there was a gap on the Wednesday afternoon, you gentlemen could use that to prepare for your closings in anticipation of what the experts, because I think if we do the experts concurrently, I think it'll speed the process up. So I think you would get time on Wednesday, and you'd also get some change out of Thursday as well, I think, for your closings, if that's of assistance. But perhaps, again, take that on board. I won't make any directions in that regard at the moment. Think about it, talk to each other about it, and see where we end up.
Yeah, I my immediate reaction is that that would be very sensible and a proportionate way of dealing with things. But I think we'll just give some further thought to the kind of practicalities of. I did a hearing recently with 6 experts in hot tubbing, and there were a list of issues, and it can get a bit unwieldy. But I think both sound sensible.
Well, I think we've only got 2, and I think the issues are relatively, you know, they've joined issue, if you like, on their respective views, and that just struck me as a convenient way of doing it in this particular case.
Well, can I just ask you on timing? If the hearing was to be remote, and Your Honour were to do the hearing from Australia, how would that affect the timetable? At the moment, I think, as you know, we're starting at 9 and finishing at 4. I think we are flexible at this end.
If you're staying in the UK, that would be unspeakably early for you, wouldn't it?
Oh no, I think we'll probably still come to Dubai.
All right. Well, that would be fine for me, except with just one little tweak. 9:30 would suit me rather better than 9. But that's just a little tweak. So if we went from 9:30 to 4:30, that would suit me well with a remote hearing.
And I suppose the other thing we need to think about if it's going to be remote is just the documentation and how Your Honour will be best helped with regards to. So we're all working from the same bundles, whether e-bundles or hard copy bundles.
Well, I'm assuming that there will be, whether we're in person or in Dubai, I'm assuming there will be an electronic bundle, or perhaps am I wrong about that? Because there's quite a lot of documents, aren't there?
Yes.
Yeah.
I think the intention is there is going to be an e-bundle.
I think an e-bundle would be great. If there's an e-bundle, if there's a manageable e-bundle, that would be perfect for a remote hearing. But again, with Dubai, I mean, once I leave Dubai, I've got to, obviously we'll have to write a judgment. An e-bundle would be much more convenient to me than boxes full of hard copy. So, is there anything else, gentlemen?
There's just one related thing on that last topic, Your Honour, in respect of bundles, that there's an agreement between the parties that bundles should be filed no later than the 27th of September. And that involved a response to our index circulated on the 4th by last Friday. We're yet to hear on that. I think there's been some recent correspondence, but plainly we need to be proceeding on the basis that the hearing is going to happen. So a response to that within today would be well received.
Mr. Liddell, are you able to respond?
Well, Your Honour, my understanding is that this has just been dealt with between the solicitors. And the bundle's due on the 27th, and I think my solicitors have confirmed they'll be providing their comments either later today or tomorrow morning. I think part of the delay is that a number of the key documents that have been disclosed to the claimants are not in the draft bundle. So there's time having to go through and work out what's in and what's not. But I'm sure between the solicitors, they'll be able to resolve this, and there'll be time to get a bundle together.
Good, excellent. Well, I'm sure with the caliber of the solicitors on this case, I'm sure that'll happen. So that'll be good. Is there anything else, gentlemen?
No, thank you.
Right.
No, thank you.
Well, I'm sorry to interrupt your afternoons, but or mornings, depending on where you are. But I think it's been helpful to have this short discussion, and we get a bit of an idea about where we might be going. And as I say, once you work out where you're going, get in touch with the court registry. They can get in touch with me, and we can put together another hearing at short notice if we need to.
I'm grateful.
Right. Thanks very much for your time. Thank you.
Thank you very much.